Judgment in the leadership dispute of the Nazareth Baptist Church. In 2019, the Supreme Court of Appeal upheld the ruling by the Durban High Court that the late Vela Shembe of Thembezinhle was the legitimate successor to the late church leader Vimbeni Shembe. The Ebuhleni faction, led by the late Vimbeni Shembe's son Mduduzi, then approached the Constitutional Court for leave to appeal the Supreme Court of Appeal ruling. The leadership battle for the church dates back to Vimbeni Shembe's death in 2011. The judgment will determine which of the two contending factions has a legal right and control of all assets of the church. Let's take it there live.
Of the full bench of the KwaZulu-Natal Division of the High Court, Pietermaritzburg. The full bench had dismissed an appeal by the applicants against the decision of the KwaZulu-Natal Local Division, Durban. The dispute between the parties in this matter relates to leadership succession in the Nazareth Baptist Church. More specifically, it concerns leadership succession in the Ebuhleni branch of the church, which formed when a leadership dispute in 1976 caused the original church, which was based at Ebuhleni, KwaZulu-Natal, to splinter into two factions. The dispute arose following the death of Mr. Vimbeni Shembe, who at the time of his death in 2011 was the leader and titular head of the Ebuhleni congregation, as well as the sole trustee of the Nazareth Ecclesiastical Endowment Trust. His son, who is the first applicant in this court, initially claimed that the late leader had orally nominated him as his successor. That nomination was challenged by the late Mr. Vela Shembe, who alleged that he had been nominated by the late leader in terms of a written deed of nomination. There are two documents which purport to regulate leadership succession in the Ebuhleni Church, namely Protocol 293 of 1935, the trust deed, which regulates the trust, and a constitution allegedly adopted by the Ebuhleni Church in 1999. The trust deed and the constitution each regulate leadership succession differently. Clause 8 of the trust deed provides for a mechanism to elect a successor should the incumbent titular head not nominate a successor or nominate more than one successor. It contains a proviso that if the titular head nominated more than one successor, the choice of successor, which was to be made by an executive and advisory committee, should be limited to the person so nominated. The Constitution, by contrast, provides for a single nominee only. Mr. Vela Shembe applied to the Durban High Court for an order that effect be given to the written deed of nomination. The factual disputes between the parties were referred for the hearing of oral evidence and related primarily to two issues, namely, who the late Mr. Vimbeni Shembe had nominated as his successor, the nomination issue, and whether succession in the Ebuhleni Church was governed by the trust deed or by the constitution, the succession issue. The first applicant, together with the second and third applicants, contended that the trust deed applied to the succession issue and, in relation to the nomination issue, that the deed of nomination relied on by Mr. Vela Shembe was a forgery and that the oral nomination of the first applicant should be given effect to. Mr. Vela Shembe contended that the Constitution applied to succession and that he had been nominated in terms of the deed of nomination. The trial court found, as a matter of fact, that the late leader had nominated Mr. Vela Shembe as his successor in terms of the written deed of nomination, and that he had not nominated the first applicant. In relation to the succession issue, the trial court concluded on the evidence that the trust deed was not adopted, used, or applied by the Ebuhleni Church, and the Constitution applied instead. On appeal, the full court overturned the trial court's finding on the succession issue, holding that the trust deed applies to succession, but upheld the trial court's finding that only Mr. Vela Shembe was nominated by the late leader. The applicant's appeal to the Supreme Court of Appeal failed. That court unanimously upheld the trial court's factual finding that succession in the Ebuhleni Church is regulated by the Constitution. After it reached this conclusion, the court noted that the trust deed, insofar as it regulated succession to the position of titular head, had been varied by the Constitution, and that this was sanctioned by the interpretive principle that, and I quote, where a later document is adopted, the parts of an earlier document that are inconsistent with it are regarded as having been varied, close quotes. Relying on this statement, the applicants applied for leave to appeal to this court on the basis that the Supreme Court of Appeal had, in effect, allowed a variation of the trust deed in breach of the Trust Property Control Act, number 57 of 1998. Notably, the applicants did not challenge the trial court's factual finding on the nomination issue, which was upheld by the full bench and the Supreme Court of Appeal. In a judgment penned by myself and concurred in by Jafta J, Kampepe J, Matlanga J, Majid J, Mhlantla J, Pile AJ, Saletsi AJ, and Chikri J, this court refuses leave to appeal on the basis that the matter does not raise an arguable point of law of general public importance which ought to be considered by this court. It reaches this conclusion because the applicants have, in effect, sought to appeal against remarks by the Supreme Court of Appeal, which are obiter dicta, that is, comments made in passing. In its judgment, the Supreme Court of Appeal accepted from the outset that the matter turned on a dispute of fact and that the factual findings of the trial court were unassailable. Having accepted that the matter turned on factual findings that could not be disturbed, the remark that the Constitution had been varied by the trust deed was simply by the way and not part of the judgment's ratio decidendi, that is the rationale or reason for the judgment. It follows that the applicant's appeal is an abstract and academic exercise at best, which this court ought not to entertain. In the result, the following order is made. Leave to appeal is refused. The applicants shall pay the respondent's costs, including the cost of 2 counsel. I hand down the judgment.
As the court pleases.
Judgment will be emailed to the parties. And will also be available on online platforms such as Safely. These proceedings have concluded.
Well, as you see, proceedings have concluded in that matter where the Constitutional Court was handing down judgment in the leadership dispute of the Nazareth Baptist Church, saying that leave to appeal has been refused with cost. In 2019, the Supreme Court of Appeal upheld the ruling by the Durban High Court that the late Vela Shembe of the Thembezinhle was legitimate successor to the late church leader. So I suppose that remains, and we'll continue to unpack the story as we go along.